Please be seated. This is the time scheduled for oral argument in State versus Mitchell. Our case number 1CACR130339. Each side has been allocated 20 minutes for oral argument. If the appellant desires to reserve any time for rebuttal, you may do so. There's a clock in the podium, but you have to manage your own time. So whatever time is left on the clock for your rebuttal, it includes your rebuttal time. To assist the parties, you should be aware that we've read the briefs, looked at the pertinent law and record, and have conferenced this case. So we're relatively familiar with the issues and the facts. Even though each side has 20 minutes for oral argument, don't feel obligated to use all of it. If you're done and we don't have any further questions, you can just sit down. Finally, you should be aware that we are both audio taping and video recording this argument. So when you approach the podium, please be photogenic, and please identify yourself by name and who you're representing. With that, counsel for the appellant.
May it please the court, I'm David Goldberg. I represent the appellant, Mr. Mitchell, and I would like to try and reserve a few minutes for rebuttal if necessary. I think this case boils down to a conflict that is not resolved by Division II of this court on two bases. And I think you can tell that from the variety of cases that have been cited by the appellant and the appellee in this case, that there is no clear law in Arizona. So there's two issues this court, I think, has to address as a matter of first impression. The first being whether the placement and long-term monitoring of a GPS unit can violate the expectation of one's privacy under the Fourth Amendment. The second part of that, unaddressed by the Estrella decision in Division II, is also whether that also can constitute a violation of the Fourth Amendment under the trespass theory, because they did not reach that issue. I don't think the state on this first aspect disagrees with the essential facts. I'm not going to belabor them, but there was a lot more in the record than considered and even recited by the trial court here that showed that Mr. Mitchell had a possessory interest sufficient to constitute a trespass in this case. I think where the court strayed was the state argued below this theory of that the real property where it was placed was the issue, and the court actually explicitly ruled on that basis, and I think the state can agree that that's an incorrect basis to rule.
If we were going to go with a trespass theory, is there any reason to remand for further factual development?
I don't believe so, because I think there's sufficient evidence in the record that this issue was pressed, and the court, deciding it on the improper basis, didn't consider it at all.
But factually, let's assume that he didn't have standing to raise a trespass as to the original placement. There's, in essence, a continuing trespass.
Absolutely.
So the question then becomes, at what point does he have a possessory interest sufficient enough on a continuing trespass to raise the trespass issue?
I think here the evidence was that he drove the car 5 to 6 times while the GPS was on it to Phoenix, and I can give you specific sites to that.
Well, I'd like to have the sites, because I've looked over that transcript real thoroughly, and I will tell you that I find the record here on how many times he was in that car not real clear. Apparently he was on it at least once, since that's the night he was arrested.
Right.
And apparently he was in the car when he went to Fat Jack's house, so we know that's probably twice. And then there's the officer's testimony that maybe he might have told him he had been in it 2 to 3 or 3 to 4 times.
Well, Detective Dart testified that he saw him driving the Kia March 23rd and March 30th. This is at pages 32 to 35 if you read it in context of item 48, which is the transcript.
I'm sorry, which pages?
32 to 35. Then Detective Dart also testified and said that, and I'm quoting, he drove it to Phoenix more than a couple times before May 30th, 2010.
I thought the testimony was they knew the Kia had gone to Phoenix a few times. That was not ever quantified. But I didn't see anything in the transcript in which he said Mr. Mitchell had been in that Kia to Phoenix on these other occasions. If you've got a site, that'd be great. I'll take it.
The sites I have that show that that the Kia was driven to Phoenix that I have are pages 50 to 52, 85 to 88, and 137. And yes, I think, Your Honor, you are correct that Detective Dart could not testify to that because he said that when he got alerts on his cell phone that the car was headed out to those waypoints, he would try, if he had time, to drive over to the residence to see if Mr. Mitchell's truck was parked there. And one time he said it did occur. But then if you look at the exhibits that were presented to the trial court, which are exhibits 1, 2, and 3, it's pretty clear that the Kia did go back and forth to Phoenix on more than 2 occasions. You also have testimony.
Maybe Mrs. Weber was in the car.
Well, that's a possibility.
How do we know that Mr. Mitchell was the driver?
Well, we have testimony that Miss Weber and Mr. Mitchell said that he drove it 5 to 6 times in that time period. And so if he was seen driving it at least 2 times on the 2 purported drug sales back before the GPS was placed, and at least twice, including the day he was stopped, and you have this coupled with the 5 to 6, then my position is that's sufficient.
Well, but I think the 5 and 6 reference was
that was Dart questioning.
soft. It was soft, I think.
I agree.
Here's the concern I have. In looking at Jones and reading a slew of other post-Jones cases, where we have a situation where there is someone who does not own the car, or the car is not really in their permanent possession, so that they are really a sporadic user. The question is, how sporadic can it be to still be in possession? At best, I mean, we're having this dialogue. I say 2 and 3, 3 and 4, maybe 5. We don't know. The record is kind of mushy on this. Is that enough for possession?
The possession comes also from the letter that
Which is
is
not in
not
our
in
record,
evidence.
right.
So all we have is the state's concession as to it. But that's why I pointed out in my reply brief, you have to take the state's concession consistent with what they argued below, which is they were not arguing that he didn't have standing. They were arguing he didn't have standing because it was placed on somebody else's real property. That was their whole argument. So they conceded below, the state has already, that he had permission from the owner to use it for a limited purpose. That's what the testimony shows. That was never clarified beyond that.
Well, isn't that your burden, though? I mean, not you personally, but isn't that Mr. Mitchell's burden?
To establish standing, I agree.
Yeah, right. And so what we have here is a soft record to decide a really significant issue. And I kind of almost feel like we're trying to take a pre-Jones record and shove it into Jones, where the record didn't quite match up what now needed to be shown.
I understand.
Yeah.
And echoing with what Judge Kessler broached before, I would think this court has the authority to remand this for further fact-finding. Clearly, it's done that before in other
But do
cases.
we need to? There's a question. I mean,
On the
how mu-
trespass theory, you probably do. I would have to probably concede that. But I still,
On the trespass theory?
on the trespass theory, I would concede that the evidence is a bit mushy, as Judge Norris called it. But I'm still submitting that there's enough here that he had use of it without limitations in terms of what he could drive it, where he could drive it, and that alone is sufficient under Jones. It's not as you read the case law that's come down since Jones, some of the courts grab onto this exclusive driver part of the Jones, and they didn't really address it because that's really dicta, because the Supreme Court didn't have to, because the government conceded that he had standing to address that issue, which is different here. The government conceded that he had permission to use the vehicle. I submit that's enough to give him standing to challenge the placement.
Let's say I normally take the bus, And maybe once every 60 days or thereabouts, or maybe once a month, maybe twice a month, I need to go downtown, so I borrow my law clerk's car, and with her consent. Do I have sufficient possession of that car so that if the state places a GPS unit in there, I can then move to suppress under Jones under the trespass theory?
If your clerk allows you to use
she's
it and
authorized
drive
me
it
to-
where you want to go, I would submit yes. You have
Well-
sufficient constructive joint possession,
I
just
do.
like in the drug
I drive the
cases.
car just once or twice, and that's enough for me to say I have possession of her car?
Well, I don't know where the
purposes of-
line is here. There is no hard and fast line, and there was none really drawn by the Supreme Court in Jones. I think that's a case-by-case determination. And until we have further definitive authority on it, that's the best that we can do is in the law here, which is, in this case, you have that it's anywhere from a couple of times he drove it to 5 to 6. But we have to look at what the trial court had when it made this ruling, which was that he had driven it before it came on the police's radar a couple of times. He followed him in the car on another occasion. That's at least 2 or 3 occasions before the GPS was ever placed. Otherwise, without that, and this is somewhat counterintuitive, but how would the detective, if a reasonable suspicion-based standard applies, how would he even have reasonable suspicion to place the GPS on there in the first place? And what he explained in his testimony was, this was the car that was being driven, and this is what his CI was telling him as well, through the other CI. I know it's like double hearsay, but it's reliable, and that wasn't contested really. This is the car he's using to ferry back and forth. So that shows that he had use of the vehicle for more than just 1 or 2 times, like the court's hypothetical. Mm-hmm. Now, I don't think you have to remand this case if you go to the reasonable expectations part of this.
Before we get to the reasonable expectation, I want to make sure I understand, because I'm getting a little confused, which, as my colleagues will tell me, happens a lot more than I.
But he's very photogenic.
That's all right. At one point, you said we could remand it, or we should remand it on the trespass theory, but then you're saying we really don't need to because the 2 or 3 times, it's not just a one-time shot. 2 or 3 times before they placed the GPS, so they knew he was using it, states conceded that he had permission to use it, and then there were 2 or 3 times they tracked him when they knew he was using it once the GPS had been installed.
Correct. I think the record's sufficient for this court to make the finding.
But you're not.
I'm saying, I learned a long time ago because I've been doing appellate law for a long time. You concede when you have to, but I'm not going to concede that you have to remand this. I'm saying the court, of course, has the authority to remand this and to develop the record, and we don't even have to go there in this case because the second aspect of this, and I'm in my position is obviously that the U.S. Supreme Court has spoken on this, that long-term tracking, and we have 25 days here, and you can look at Exhibits 1, 2, and 3 is all you need to do, which the trial court said, no, Knotts covers this. Knotts doesn't cover it.
But long-term tracking of what? Long-term tracking of the Kia, but not Mitchell's use of the Kia, because at most it's 4 or 5 days, let's say, that they tracked him, as opposed to at least the facts or the concession in Jones that he was the exclusive driver.
Right.
So yes, any tracking of the vehicle would be tracking of Jones. Here, the tracking of the vehicle, even for a long period of time, would not necessarily be the tracking of Mitchell.
Well,
So-
except for when Detective Dart got a text on his cell phone saying, well, the Kia went to Phoenix.
Well, that doesn't mean it's Mitchell.
Well, then he's going to find out if it is Mitchell. He found out at least on one occasion before this that it was Mitchell because he went to the house and Mitchell's truck was
But that's
there.
one time. And
Right.
there's a couple of other times that as you've forthrightly stated, that there are, maybe 4 or 5 times that they know it's Mitchell driving. Is that enough for long term? Because otherwise they're just tracking the vehicle. And so my concern would be that if we went to the reasonable expectation test, we'd either have to adopt Justice Sotomayor's view that 1 day is enough, at
Right.
least short term's enough. Or we'd have to remand for further factual development to see how often it was being tracked when he was using it.
I understand. I don't think the court has to draw that strict of a line either to resolve what Justice Sotomayor, her concern was, if you look at, or for that matter, your colleague's dissent in Estrella, because I believe his position is the same as Sotomayor's.
Yeah.
But if you look at the Zahn decision out of South Dakota that I cited, which is the most expansive, at least state Supreme Court case I've found on this, in that case, it wasn't clear that the same person was driving the vehicle and that multiple people were driving it. In that, they adopted basically the rule of 5, because as I cited in my reply brief and in my supplemental citation that I filed last month, the rule of 5 applies to this case, meaning the U.S. Supreme Court has said through 5 justices that long-term tracking is a violation of one's expectation of privacy. And I don't know if the court got just the other day, I know by rule you don't have to consider it, but I also cited a more recent Ohio Court of Appeals case. And if you look at the authorities are starting to line up. I think what also is critical here to consider is Detective Dart testified, and if we're not even going to get into the good faith and the Davis part of this whole thing that no other Arizona court has addressed yet either. I haven't found a reported decision addressing the Davis exception to good faith exception, but that he even admitted twice during his testimony that he could have got a warrant to place this. So where's the expediency here? And we're going to do away with that. That shows if he could have gotten a warrant, as these other states start to, in light of Jones, adopt GPS monitoring warrant requirements and statutes, and case law starts to line up, it's lining up on the privacy side. It's not lining up on the you don't need a warrant side. And so that shows that, and the reality is that the growing consensus is becoming that even tracking him to Phoenix on the 30th in a lot of legislatures and judicial minds now is too much. It's too much of an invasion to know that at 8:15 p.m. he's here and he's stopping at the gas station up at Cordis Junction, and he's there for 5 minutes, and then he's going to this house for an hour. And they use that to prove guilt without a warrant, without an exigency, without probable cause, even though the officer admits here, and this is at pages 93, 95, and then later at 113, there's at this time, no police protocol by the Yavapai County Sheriff's Department as to when he can place a GPS. It's completely up to him, even though he admits, I could have gotten a warrant. So why don't we have, just as we do when you have any invasion of somebody's personal effects, before you can go into somebody's house, before you can go into a car locked in a driveway to search it, the same judicial scrutiny before the invasion occurs on whether there's probable cause. So I'm going to ask the court, and I'm going to try to keep my last 3 minutes here, to whether the court has questions about the status of the record or not, adopt the expectation of privacy issue. And I'm given by the questions, I'm not going to get into at this point the Davis exception, because the record clearly is clearly insufficient to show that Detective Dart relied on some precedent. He actually stated to the opposite, the cites that I just provided to the court. He didn't decide on any basis. He decided on being a police officer for 10 or more years. So I'll save my 2 minutes and 40 seconds if.
Okay. Thank you.
May it please the court, Lindley Wilson on behalf of the state of Arizona in this matter. I'd first just like to direct this court's attention to Estrella, which was discussed in both of the briefs filed from Division 2. Estrella doesn't present a conflict, and in fact, it's very factually similar to this case. In that case, the officers had reasonable suspicion to start investigating a drug-related vehicle and placed a GPS device on that vehicle. And this court already extensively considered Jones and its applicability in this sort of context, and even noted at one point that A person's expectation of privacy while traveling on public roads was addressed squarely in Knotts, and noted that the Supreme Court has not qualified or retreated from that position, and there was no need to in that case.
Australia doesn't deal with the trespass issue.
Right, and this goes more to the second part, but and I recognize that that theory hadn't been articulated in that case, and so the court declined to address it. But nonetheless, Estrella also sort of shows that the extent of the monitoring in that case and in this case isn't this long-term monitoring that even Justice Sotomayor was concerned about. This is, the GPS device was set up to just send text messages when this vehicle crossed certain waypoints, and one of those waypoints was Phoenix. And so even in Estrella, this court noted that the use of the GPS device was much more limited, and just that even, first of all, there's no need to remand this case at all for further factual findings on the extent of this GPS monitoring, because it's all in the record. It's all very clear. This wasn't just a fishing expedition to find out, what his habits were, or associations, or anything like that. It was for a very specific purpose. And the evidence was that he, as judges have pointed out, that he had driven it between 3 and 5 times or somewhere in there. So the evidence is that it was, his permission to use this vehicle was very sporadic and on occasion, and it certainly doesn't rise to the level of what we've sort of phrased as standing to assert a trespass violation.
Go ahead.
We know he had 3 to 5 times. How do we know that he had permission to use it 3 to 5 times? Or just presuming that because he drove it, he had permission?
Well, even the owner of the vehicle, Miss Weber, told the detective at one point that, let me just make sure I have it accurate. She said that he had driven her car 5 or 6 times, so that's from her. And he told the detective he had driven it 3 or 4 times, and that's at page 103 of the transcript.
He said, detective said that Mr. Mitchell told him 2 or 3 or 3 or 4.
Right, and so sort of between that 2 and 4 range, somewhere in there.
That's both at page 103 of the transcript?
Yes.
Okay. So
Why isn't that
That's
enough
it.
for trespass?
Yeah, why isn't that-
Isn't, I mean, you have Mrs. Weber, the detective, Mrs. Weber telling the detective 5 or 6. He's got 2 or 3 or 3 or 4. We know that the sheriff had connected him with the Kia. That's why they put the GPS unit on the Kia to begin with. And there are multiple trips, or some trips, numbers of trips to Phoenix, although we don't exactly know if he was the driver, but I think there's probably a fair inference he might have been. And then we have, I thought, the state conceding that he did have consent, and there's some form of concession, I'm not sure exactly the scope of it, in the trial court about standing for something.
I believe the extent of the state's concession and talking about this letter, which as has been pointed out, is not in the evidence at all. But the extent of that concession was just acknowledging that he was, I think, in possession the night he was arrested, and that he had permission to use it on occasion, and that's basically the extent. It's not that the state just completely conceded that he had some sort of possessory interest in the vehicle sufficient to give rise to a...
Well, they didn't, there was never any assertion that he didn't have consent to use it
No, I mean,
during the period of time of the tracking.
Right, and I think that's all the prosecutor was pointing out, is that we're not disputing that, no one's saying he
Okay.
took this vehicle without consent or something.
So he has consent to use it. He uses it 3 to 5 times, 2 to 5 times, 2 to 6 times. And why isn't that enough to argue, give him standing on trespass? And especially given the trial judge in her original order on the motion to suppress said he has standing to object to the use of it, to the use of it. Why is that enough not to give him standing?
I think we just have to go back to the to looking at what we're talking about. We're talking about possession of the vehicle, and that's why he has standing to assert a challenge as to the monitoring is because he was actually in possession of the vehicle. And so it is a significant fact that the vehicle was parked not outside of his residence, but outside of the registered owner's residence.
That's on the
And so-
placement, but on the monitoring, the use of the monitoring, she held, he has standing.
Right.
You're not contesting that.
Right, and that's not a problem. It basically under knots, it's not a search, and
Well, it's,
or not one that he
but
can
the
assert
placement's not, this placement's not a search.
right in this case.
But it's the use, and she's saying, well, Knott says the use is not a search. And I think the use is a search under Jones. So, I mean, it's a non-consensual search because there's no consent by the owner or him.
I guess that maybe the better way for me to put it is he can assert a Fourth Amendment challenge as to the use and monitoring of it, but that challenge fails under Knott's because the Supreme Court's already recognized that your public movements on public roads isn't, you don't have a reasonable expectation of privacy in your movements on public roads. And that's what a lot of the cases we've cited have held under Knott's is perfectly fine.
And under Jones,
Well, and even if we talk about Jones,
don't we have to?
well,
Unless you'd
I-
like us to disagree with the U.S. Supreme Court.
no, I don't. I think part of the analysis is under Jones is that the Scalia and Sotomayor opinions are the controlling opinion, and Sotomayor specifically declined to join the Alito concurrence, and so that's where all of those questions are posed about long-term monitoring. But again, in that case, we even had 2,000 plus pages of data that was used and tracked, and it's just so unlike this
But
case
what about the trespass, though? I mean, clearly on a trespass theory, there was a search. Using the
as to the use and
as to the
monitoring.
use.
I don't think even that theory has been articulated below or here on appeal, so it's still not the appropriate case to decide that issue here. And
Well, let's talk
and even
about
if,
placement then. What about, why isn't, given, we do have a mushy record, I think, but nevertheless, we have, at least in single digits, 2 to 3 to 3 to 4, maybe 6 uses, and we know quite clearly the police or the sheriff's office was targeting that Kia with Mr. Mitchell in mind. I mean, there's no question about that. That is why they placed the GPS on the car. Why isn't that enough for a standing based on a trespass theory regarding the placement of the GPS? I mean, they were looking to get him. They weren't looking to get, Joe Blow down the street who lives in Cordes. They were looking for Mr. Mitchell.
he still just had not established, I think, significant enough of a possessory interest in this vehicle. And so,
What did he need to show then?
at a minimum, I mean, there's been cases talking about that you're maybe not the owner, but at least a frequent driver, or I know in Jones they didn't quite elaborate on this point, but an exclusive driver, or just someone who, would take basically responsibility of this property. If something had happened and someone damaged the vehicle, I don't think that appellant would have any sort of claim to any sort of damage to the vehicle, or it simply has to be more, I think, under Jones.
But what's the more? Help me on this, because I've
Well, and
read
I
a
think
slew of these cases, and I think we have the extreme where Jones is a easy case because although it was it was titled with Mr. Jones's wife, he was the exclusive user. Well, that's easy. Then we have the case where someone on the other end of the spectrum maybe uses a car once. Well, okay, that's not good enough. So then we have the case we're presented with. So is this enough? And if it's not enough, why not?
quite simply, he just wasn't in possession of the vehicle at the time the GPS device was attached. I think that's a critical fact. And the Figueroa Cruz case.
So he had been
we just
living at
recently
Mrs. Weber's
cited.
house the night the GPS was put on the vehicle. That would have been good enough?
If he had been living there?
Yeah.
Just that single night?
Yeah?
I mean, then
that
you
have
get
been
in,
enough?
we would have to get into a whole discussion about, I guess sort of his, I don't know the answer to that question. I
Relationship
think
with
it
Mrs.
I think
Weber?
it does. I think it does depend on the facts highly. And in the Figueroa Cruz case we just recently cited, that court held there was no Fourth Amendment violation concerning the placement because, quote, there was absolutely no proof the defendant was in possession of the vehicle at the time the device was attached. And there's
So is the
several other
point you're
cases.
making is that in order for the trespass theory in Jones to apply, the person who might not be the owner of the car nevertheless has to be in physical possession of it at the time the GPS is attached? Is that the state's argument?
Yeah, I think that's a critical part of it. And I mean, there might be more. I can't think currently of, any other facts that might indicate possession other than physical possession, but it's physical possession, says quite a bit. And there's several cases we have also cited in our answering brief, just finding either standing or no standing based on where the vehicle was at the time it was placed.
I still going back, unless Judge Morris had more, I still go back to the use. Let's assume that you borrow one of your peers' cars, and unbeknownst to you and unbeknownst to him, the police have placed a video camera so they can watch everything you're doing, as well as a GPS, because they're interested in you. And they know that once or twice in the past you've used his vehicle, and they want to see if perhaps you're leaving work to do something inappropriate. Do you have standing on a trespass? As opposed to, in contrast to, two FBI agents, let's say, following someone who's leaving the office at noon, and they're tracking him. I mean, do they have, which wouldn't be a search because they could track him. They're interested in him.
Sure.
But if you used the car and went somewhere and the police were interested in you, but they were just going to track all your movements in that car, doesn't that give you enough to challenge on a trespass theory because you were in possession?
Well, a trespass theory is, premised on some invasion of personal property or privacy or whatnot. And so I think perhaps the better test is the reasonable expectation of privacy test in a situation like that where the hypothetical was someone just gets into a car, right, and then they've got a video camera installed or something. So, I don't know that would work under a trespass theory, but perhaps they could assert some
Reasonable expectation as far as the
something
camera.
under,
But okay,
right.
so it's just GPS. So you borrow your peer's car to go somewhere, and the police know you've borrowed it a couple of times in the past. And so they're tracking you, and they find out you go to certain locations, and they want to use that in a criminal prosecution. You don't have standing to say, wait a second, I had possessory interest in this car.
Under trespass theory, I don't think so, because the device has already been placed, and
And what's your
case law
authority?
looks at those
What
two.
case do you say that you have to have possessory interest when it's placed to argue possessory interest on the use?
What case stands for that?
Yeah.
I mean, I think that just comes right from Jones, that it's two separate analyses as you look at standing as to placement and standing as to
Right, but
use.
on the trespass issue, though, I mean, trespass as to use. I don't have standing to raise the trespass as to placement because I wasn't in possession at the time it was placed. But I use it when I'm using it, I have possessory interest, and it's being used to track me. You're saying because I didn't have possessory interest when it was placed, I don't have possessory interest when it's used.
I just don't think I just don't see how trespass analysis works in that context, because I think the better assertion there would be that it violated your reasonable expectation of privacy, which has been around since cats. And so,
And before we run out of time, this whole idea of the good faith exception.
sure, I wanted to talk about that also.
What do you do with this idea of there was no protocol? I mean, he just did it because he thought he could do it.
Well, in all of the cases post-Jones talking about the applicability of the good faith exception under Davis and the exclusionary rule, those courts have simply looked at the law at the time, the state of the law at the time the GPS device was placed, in determining whether that was objectively reasonable reliance on then existing precedent. And
So it's an objective test.
I think it is, yeah. I think that's pretty clear from the court, from the cases out there talking about this. And
Protocol's meaningless.
Well-
Having somebody, whether he knew or didn't know,
And even on this record, I think there's enough there to show that the Detective Dart was acting in accordance with what he believed the law was. In fact, at one site, which is page 93 of the transcript, he's cross-examined and asked, did you have the opportunity to approach a magistrate to get a search warrant to attach the GPS unit? And his answer was, my understanding of the law was, and then counsel cut him off and said, I'm just asking if you had the opportunity to get a search warrant. And he said, yes, but I chose not to. He had also testified that he had used GPS devices about, I think, 4 or 5 times since 2007, and that's at page 134. And so, the purpose of this exclusionary rule is to deter future Fourth Amendment violations. And so even if we want to look at the record and apply some sort of subjective test, even though I don't think that's necessary, you can quite clearly see that there was no goal to get around any sort of thing, that everyone just believed that it was
but the
fine at the
objective
time.
test, so you're saying based on CARO, so if I read your briefs properly,
Right.
and forgetting the Ninth Circuit, because that's not binding precedent on us.
Fair.
But basically, CARO is, you're saying, that would give us the objective test,
And
for
we're talking about
good faith.
placement of the device or
placement and use.
use, both. So I think knots had been around since the 80s, so clearly based on knots. And the case that we most recently cited on this issue in our supplemental authority is Aguiar. And in that case, the court noted that several circuit courts have applied the good faith exception in cases where warrantless GPS searches were conducted pre-Jones and did not require suppression of evidence, and concluding the officers relied in good faith on knots in placing the GPS device on defendants' vehicles.
Knots and CARO both involved consensual placement, right?
Yes, it was that involved beeper technology.
Right.
But,
And
but
they-
there's the key component that Judge Kessler is noting, is that each case involved a situation in which the original owner or possessor of a container or another object agreed and consented to the placement of the beeper. And so the defendant in each case, and Knott's is a little different than Caro even, was a recipient of an item that the original possessor had already consented to. And that, to me, and the emphasis of that fact in Jones suggests to me that there wasn't any binding precedent here for purposes of Davis.
Well, there was at a minimum knots, which, at least established that the electronic monitoring of someone's, movements on public roads is okay. And there was also...
Under a reasonable expectation test.
Right, because we didn't have any sort of trespass theory at that point. And there was also nothing, out there. There was no circuit split or anything saying that it was impermissible or that it would be a Fourth Amendment violation. And so...
It's got to be binding in our jurisdiction.
So you
I know of nothing in Arizona, so the only other court that's better than we are would be the United States Supreme Court.
Sometimes.
Yeah.
Sometimes.
Yeah, and so...
And those are
Right.
in those cases, they discuss knots extensively, and just, even though, the facts may be a little bit different, it still stood for this general proposition that it could be relied upon. And
But trespass wasn't unheard of at the time. I mean,
Right. And even at the
trespass, the
time
idea
of-
of a trespass was around for a long, as Justice Scalia has pointed out, around for a long time. And Knott's didn't deal with that, and it didn't deal with a non-consensual search, non-consensual placement and use.
right.
So the owner knew it was placed and knew it was going to be used.
And, even though the Ninth Circuit isn't binding on us, I think those two cases, McIver and Pineda Moreno, still were pretty much right on point with the placement of a GPS device. And we're talking about a federal, constitutional violation, and so they're still persuasive and instructive. And,
But the test is binding, right?
well,
Is the test binding?
the test says binding, but there have been cases discussing, and I believe we've cited them, that it's not a literal test. And I think courts kind of go both ways on this issue. Some apply a very literal test that it has to be strictly binding. But in the case of Aguiar, which we just cited, that case cited a Baez case, which is Massachusetts 2012, and the language they used is The officers, at the time they acted, had a good faith basis to rely upon a substantial consensus among precedential courts. So I still think that even though it is the Ninth Circuit, it's still helpful and instructive, and certainly there was no bad faith here and no future Fourth Amendment violations to deter. So I see I'm out of time, but the state just requests that this court affirm. There's no need to remand for any factual findings, and thank you.
Thank you.
It's the first time I've ever heard the state get up here in any appellate argument and ask you to follow the Ninth Circuit. So
Don't tell anyone.
That's a first.
Okay.
I don't know what
We'll note it for the record.
the Attorney General would think about that. But anyway, the Aguiar case actually that was just alluded to is in the minority view. There's only 2 circuits that follow that, and one's the First Circuit. And if we're going to go down the good faith rabbit hole here, and the test isn't did the officer act in bad faith, that would turn the whole good faith exception on its head. You have multiple other courts disagreeing, and the most thoughtful, in my opinion, discussion of this is the Katzen case, which is I cited in my opening brief and as well as my reply brief. That's the Third Circuit, and there's multiple courts lining up on that side saying it's got to be binding, it's got to be in your jurisdiction, you can't allude to something else, and it's got to be objective. We're going to just throw out the fact that he said, I relied on my own sense. That doesn't matter?
It's got to be objective, because otherwise you have a good faith, empty-headed test.
Exactly.
And an officer could always come in and say, oh, gee, I acted in good faith. I didn't think this was it's an objective test.
So the courts are kind of lining up on both sides, but they're lining up in my at least snapshot view is to say Knotts and Caro didn't cover this situation with GPS and continuous monitoring where you can find somebody.
And that's because they were consensual.
Right. And also because it was just a beeper technology, it's not as intrusive, it doesn't give you as much detail, and that's what they're turning down on. I want to go back to something the state said, though. I think what's happening here is the state has been talking out both sides of its mouth, with all due respect, about what standing is. Well, you have standing, and then in their answering brief, they're saying on appeal that standing is not really a separate free-flowing issue. Below, they're conceding standing. Now it's all part of whether somebody has reasonable expectations of privacy. It's not you can't have standing. The state's whole argument here misses the long-established principle of law that somebody can have constructive possession of property. They don't have to be in physical possession. And when Judge Kessler asked the state just now, can you point to a case that says you have to have actual possession? Mr. Jones didn't have actual possession. You'd have to be sitting in the car with controlling it under the state's theory here to have standing to challenge the placement. So the only thing we have to get to on this is if the car had been stopped after Mr. Mitchell got out and went to bed and they found the drugs in there, would he have sufficient constructive possession of it to be criminally liable? Absolutely. And the state would be here arguing he had sufficient possessory interest to show that he had exercised control and dominion over the drugs. So why do we apply a different standard when it comes to the Fourth Amendment? And I'm submitting under Jones, we don't. Constructive possession's enough.
But we don't have to worry about constructive possession, do we?
I think he had actual possession when it was being monitored. That's the whole piece of the puzzle that really the court, the court below, and I beg the court's a little bit of indulgence here, but the court below didn't even reach that because in the trial court's opinion, Knotts is all that matters. But the Supreme Court in Jones wasn't dealing with, are we overruling Knotts? They're saying this new, actually, as probably Justice Scalia would say, this resurrected trespass theory that we put on the shelf for about 40 years now is part and parcel. It's not an and, it's an or.
Right.
And that's clear. They say that, even the majority. And because when we have this 4-1-4 split, it's
You don't have a 4-1-4 split.
we have a 9-0 decision here.
Yeah, right, but you have 5.
The narrowest holding.
We have 5 and 5, in essence.
Right. So I think this court, if we're going to look at precedent, this court can reverse on either basis, either trespass or reasonable expectation, and not violate the binding precedent.
Thank
Thank you.
Counsel. Yeah, thank both counsel for their presentations. It's very helpful. We will take this matter under advisement and issue a written decision in due course. We will take a brief recess to allow the parties to the next oral argument to approach.